Welcome to today's webinar on proprietary estoppel and the question of who inherits first. For those of you who don't know me, my name's Ali Toe and I'm one of the senior associates in the dispute resolution group here at Boyce Turner, and I will be hosting today's webinar. This is a live webinar, so please feel free to post any questions you may have as we go along through the chat panel. This webinar may raise a number of questions, so please bear with me. I will try and answer your questions at the end of the webinar, but for any of those that I'm unable to respond to, I will endeavour to get back to you separately. I may not be able to answer specific questions on air, as I may need to understand more about the context of the matter and the question. However, if you do need to talk to me about a specific matter, please contact me directly and I will come back to you separately. Although live, today's webinar is in listen-only mode. However, as I say, you can send us any questions or comments through the chat panel, and I will do my best to answer as many of them as I can at the end of the webinar. This is the fourth webinar in a series that we've been running throughout the year on the question of contentious probate claims. We've already looked at the question of lack of testamentary capacity and wanton knowledge of approval of wills, undue influence and forgery of wills, rectification of wills, lost wills and deathbed gifts. And still to come in the series are Inheritance Act claims and removal of executors and administrators. But today we're going to be looking at the question of who inherits first under an estate and proprietary estoppel claims. So let's get started. So who inherits first? Scarl and Scarl was a very interesting and slightly unusual case which was heard last year. The facts of the case do not relate in any way to proprietary estoppel claims, but it's one of those rare cases that come up every now and again, the facts of which are very relevant in the context of overall probate claims. And so I felt we had to include it in our series of talks. Scarl is quite a sad case. Mr. and Mrs. Scarl were both found dead at their home on the 11th of October 2016. They had both died from hypothermia. Both Mr. and Mrs. Scarl had children from previous relationships. Mrs. Scarl had made a will leaving her estate to her husband, or in the event that he should predecease her, to her daughter. Mr. Scarl had not made a will. As such, his estate would pass under the rules of intestacy, so the majority to Mrs. Scarl, and then the balance to his daughter, or if Mrs. Scarl had predeceased him, the entirety to his daughter. The question for the court to consider, therefore, was who died first. Central to this question was the operation of Section 184 of the Law of Property Act 1925. This provides that in all cases where two or more persons have died in circumstances rendering it uncertain of which of them survived the other, such deaths shall, subject to any order of the court, for all purposes affecting the title to property, be presumed to have occurred in order of seniority, and accordingly the younger shall be deemed to have survived the elder. Whilst at 69, Mrs. Scarl was younger than her husband, and on a strict interpretation of Section 184, therefore, she would be held to have survived her husband. She was fully dependent on her husband for her care and mobility, having suffered a stroke in 1988 or 1989. Mr. Scarl's daughter alleged that the presumption in Section 184 was rebuttable if she could prove on the balance of probabilities who died first. In the face of such proof, she said it could no longer be said that the sequence of death was uncertain. The pathologist who conducted the couple's post-mortem examinations gave evidence to the court that he thought the changes of decomposition were less advanced in Mr. Scarl, which may suggest that he died after his wife, possibly a few days later. However, temperature and environmental issues are contributing factors when considering the question of decomposition, and the couple were found in different parts of the house, and so it could not be said that decomposition would have occurred at the same rate. Indeed, it was common ground that even if the bodies had been in the same room, not all bodies decompose at the same rate. In all the circumstances, the court concluded that the order of death remained uncertain. Mr. Scarl's daughter had not satisfied the court that on the balance of probabilities her father had died last. Accordingly, the presumption of section 184 was effective, with the result that Mrs. Scarl was presumed to have survived her husband. Mrs. Scarl therefore inherited the majority of her husband's estate under the intestacy rules, and her daughter in turn inherited her estate, including Mr. Scarl's estate, under the terms of her will. So as I say, quite a sad case, but quite important in the context of matters that do come up every now and again. So then turning to the question of proprietary estoppel claims. Proprietary estoppel claims are finding increasing favour with families, and although they can be brought after a person has died, we are seeing an increase in the number of cases brought whilst the testator is still alive. Interestingly, a large amount of the cases which the court has had to consider over the last few years have been in relation to family disputes over farms and the way in which they are run as businesses. But proprietary estoppel claims do not need to involve a business or indeed farmland. There's no legal definition for proprietary estoppel. Various attempts have been made by the courts over the years to do so, but without success. However, what is now clear is that there are three key ingredients essential for a successful proprietary estoppel claim. These key ingredients are a representation, promise or assurance made to the applicant, the party bringing the claim, a reliance by the applicant on that representation, and a detriment being suffered by the applicant as a result of that reliance. Lastly, the court will usually apply a more general requirement that it would be unconscionable for the relief sought not to be granted. So how does the court interpret the key ingredients? Well, let's have a look at that in more detail. The representation, promise or assurance must be sufficiently clear or unambiguous for the applicant to have reasonably relied upon it. A general promise that provision might be made in the future is not sufficient. However, an assurance that provision will be made by way of a will can be sufficient, even though a will can be revoked or changed during the testator's lifetime. Usually, saying or doing nothing will not be sufficient, but standing by in silence in the knowledge that a party is acting to their detriment in the mistaken belief that they are or will be entitled to a proprietary interest can give rise to an estoppel. Representations alone do not give rise to an equity. There must also be reliance on the representation by the applicant. The form of reliance will depend upon the representation made, but it must be reasonable. Where the representation is too vague or made in circumstances where it could not be expected to be relied upon, it will not have been reasonable for the applicant to have done so. And so what then about detriment? It can be difficult to establish that the applicant's steps up to the representation were or were sufficiently to their detriment. In theory, a person is always capable of going back on a promise made to another person. What makes the promise irrevocable, or at least capable of supporting a proprietary estoppel claim, is the detriment that is incurred in reliance on the promise made. The court will also consider the question of detriment from the point when the promise was not fulfilled. A common issue when considering the question of detriment is also what would the applicant have done irrespective of the promises made. So for example, in a farming context, would the applicant have remained working on the farm in any event? And in cases where the applicant provides care in reliance upon a representation, would they have provided that care in any event, particularly if the relationship was one of love and kindness? Proprietary estoppel claims, as I've said, can be brought both before and after the promiser's death. Claims rely upon the equitable jurisdiction of the court, so should be brought in the High Court. Claims may arise in a number of different contexts, including as a freestanding claim in its own right, as part of a wider claim involving claims challenging the validity of the will or an Inheritance Act claim, or as a defence to any claim for possession proceedings in relation to property. Each case will turn on its own individual facts. These can be demonstrated by 3 recent cases, which on their face had similar facts, but which brought different results. So let's look at each of these in turn. So first of all, the case of G&G in 2018. In this case, the court considered that the key ingredients had been met and upheld the claim. John G was one of 3 surviving siblings. He brought a claim for proprietary estoppel in relation to the family farming business at Denman's Farm, worth about £8 million. John was 60 years of age by the time he brought his claim. He had started working on the farm in the 1970s and continued to do so all his working life until 2016, following a fallout with his brother Robert, after his father had transferred his shares in the business to Robert. In the proceedings, John asserted that since about the age of 30, his father had repeatedly told him he would inherit the lion's share of the farm and that he had relied on those representations to his detriment, essentially by devoting his working life to the farm and working long hours for low wages. In the circumstances, he contended that the transfer of the shares to Robert was unconscionable. John could not remember details of each and every occasion when his father had made the assurances, but he also relied on evidence from other witnesses who corroborated John's contentions as regards the assurances made to him by his father. The court upheld the claim. In order to satisfy the equity, the court ordered that shares be transferred from Robert to John so that he would end up with a 52% shareholding in the business. There were also some further orders made regarding the transfer of land. And then in James and James, another case in 2018, and which some of you may remember we considered earlier in the series of these webinars on the question of lack of testamentary capacity. Raymond James, known as Sam, brought a claim against his mother and 2 sisters following the death of his father. Conversely to the G case, the court did not consider the key ingredients had been met and dismissed the claim. Sam had worked on the family's farm since he was 15 years old. His father had been a difficult man, but they had managed to run a successful farming business. His father had kept all the assets in his sole name until he began to show signs of dementia, at which point they were transferred into the joint names of him and his wife. Throughout his lifetime, Sam said his father would often ask about his views about land which he was considering buying, saying, "You are going to be farming it one day." He also understood and acknowledged that when his parents died, Sam and his wife would take up occupation of the farmhouse. In 2010, his father made a new will which cut Sam out. Sam brought a claim for proprietary estoppel. The court dismissed the claim, noting that there was nothing with a sufficient degree of clarity to amount to an assurance. I should say James is being appealed, and so the outcome may well be reversed on appeal, but as it currently stands, his claim has been dismissed. And then in Guest in 2019, this was another case involving a family dispute in relation to a family business. The court upheld a claim brought by Andrew against his parents, David and Josephine. David Guest owned land and buildings at Sedbury, from which he operated a farm, Tump Farm. He lived at the farm with his wife, Josephine, in the main farmhouse. Mr. and Mrs. Guest had 3 children, Andrew, another son, Ross, and a daughter, Janice. Andrew had worked full-time at the farm since 1982 when he left school aged 16 until 2015 when he left the farm. Prior to his departure and since 2012, Andrew had operated the farming business in partnership with his parents. However, in 2015, they sought to propose a new partnership which Andrew did not feel able to accept, and so he left. Since his departure, Mr. and Mrs. Guest had continued to run the dairy farm by themselves, the previous partnership with Andrew having now been dissolved. In August 2017, Andrew issued proceedings seeking a declaration that he was entitled to the entirety of the farming business, including an additional property situated on the land known as Granary Cottage, and in which Andrew had occupied with his wife and subsequently their 2 children since June 1989, following their marriage, until he left the farm in 2015. By this time, Ross, his wife, and their children were also living at the farm, although Ross was running another farm in partnership with his father. By the time he issued proceedings, Andrew was in his 50s, and his claim was brought based on the detriment he had suffered in working at the farm since he was 16. He alleged that his working week comprised some 60 to 80 hours, for which he received only a modest income. For example, just over £11,000 in 2008, although the business did pay for certain of Andrew's household expenses, and he and his wife did not pay any rent for their occupation of Granary Cottage. Andrew relied on various promises and assurances that he had received from his father throughout the time when he had been employed at the farm, that he would one day take over the farm. He also pointed to specific succession right discussions which had taken place in 2009 following a dispute over wages, and which had ultimately led to the creation of the partnership deed in 2012. By the time of the proceedings, he admitted that over time he had accepted that any promises or assurances had diminished somewhat, with an understanding and expectation that he would inherit the farm and business jointly with his brother Ross. So far as Andrew's parents were concerned, they denied having made any promises or assurances. They said whilst their intentions had changed over the years, at no stage had there been any intention that Andrew alone would inherit their estates. This, they said, was supported by their positions as regards the execution of their wills. In this respect, the court heard evidence that as early as October 1981, David had made a will on terms that Andrew and Ross would inherit Tomp Farm in equal shares, but on condition that they raised sufficient funds to pay a pecuniary legacy to their sister Janice, which was equal to 1/5 of the value of the residuary estate. Josephine's interests were also protected by way of a life interest in relation to occupation of the farmhouse. Josephine herself also made a will at the same time in almost identical terms. By the time the court was considering the claim, things had moved on, with David having recently executed a new will in January 2018. David's new will, whilst continuing to protect Josephine's ongoing occupational rights, now provided for the farm and business to pass to Ross, with Janice receiving the sum of £120,000, together with a small parcel of land behind the farmhouse, but with no provision being made for Andrew. Josephine did not execute a new will at that time, but their case was that they'd already begun to move away from any desire for Andrew to inherit, as she had executed a new will in 2014, which made provision for her sister-in-law to receive a pecuniary legacy, and then divided her residuary estate equally between her 6 grandchildren, including Andrew's 2 children. Mr. Justice Russin stated that having considered the parties' evidence, he was satisfied that until the falling out in 2014, David had consistently over time led Andrew to believe that he would succeed to the farming business, even though by the late 1990s, Andrew had been aware that this would be alongside Ross. In his judgment, David's statements were clear enough to amount to an assurance that Andrew would inherit a sufficient stake at Tump Farm to enable him to carry on farming after his parents' deaths. He also found that David's assurances had the tacit support of Josephine, particularly having regard to an entry that she had made in the partnership records that he would inherit a substantial share of Tump Farm, he being Andrew. Mr. Justice Russin considered that Andrew had acted on the assurances received from his father with Josephine's tacit support to his significant financial detriment. That, he said, was obvious from the fact that Andrew had worked hard on the farm for many years for little financial reward. He would not have done so had David not encouraged the idea of an inheritance. Mr. Justice Russin found that David and Josephine had resiled on their assurance that with Ross, Andrew would take over the farm. He stated that the dissolution of the partnership and the matters which led to its dissolution had no adverse effect on Andrew's claim, the formal partnership itself coming into being very late in the timetable of events upon which Andrew relied. He therefore found in Andrew's favour and made an order providing for Andrew to receive a lump sum calculated on a percentage basis of the value of the farm and business. These cases demonstrate how apparently similar cases can lead to different outcomes depending on the specific facts of the case. They also demonstrate the importance of having strong evidence to support any claim of assurances or promises having been made, together with a reliance upon them. So that concludes this brief look into who inherits first and proprietary estoppel claims. So it just remains for me to say thank you then for listening, and to say I look forward to welcoming you to our next webinar, which is scheduled for the 7th of September, and when I will be considering the question of Inheritance Act claims. So look out for details of how to register for that shortly. In the meantime, once again, many thanks for listening. Thank you and good morning.